Judge Liman just ended Blake Lively's fairy tale lawsuit against Jed Wallace in one brutal sentence. Not with a gavel, not with a speech. With a single surgical dismissal that vaporized every claim that Lively tried to pin on Wallace, and did it so cleanly you could hear the case crack in half from across the courthouse. The order dropped like a grenade. Liman didn't mince words. Wallace never lived in New York, never worked there, never conducted business through there, and never controlled any countersuit filed there. Zero connection. Federal courts don't do fairy dust jurisdiction, and Liman wasn't about to start. Lively's legal team had thrown 3 separate theories at the wall: conspiracy jurisdiction, in-state injury, transactional ties, and the wall didn't just stand, it laughed. Here's where it gets good. Lively's team painted Wallace as the puppet master, the shadowy figure orchestrating a campaign to destroy her reputation. Months of discovery, depositions, document dumps. And when the smoke cleared, nothing. No funding trail, no smoking gun emails, no proof Wallace directed anything. Judge Liman's response was judicial poetry. Speculation isn't evidence, and vibes don't belong in federal court. Every jurisdictional argument collapsed under scrutiny. Conspiracy, rejected. No evidence that Wallace coordinated with anyone to harm Lively in New York. Injury within the state. Dismissed because people saying mean things about you online isn't a geographic injury. Business dealings in New York. Non-existent. The court didn't just reject these theories. It dismantled them with the kind of precision that makes law students weep. Then came the kill shot. Judge Liman essentially wrote, "This isn't about workplace discrimination, this is about hurt feelings." Every single claim in Lively's complaint circled back to one thing. Her reputation took a hit, and she didn't like it. That's not retaliation under employment law. That's defamation wearing a disguise. The order gets sharper. Lively wasn't fired. She wasn't demoted. She wasn't denied promotion. She was criticized, publicly, harshly, and in her mind, unfairly. But Judge Liman made the distinction crystal clear. Reputational harm is not a workplace injury. You can't file a civil rights lawsuit because the internet turned on you. This section should be taught in every law school in America. Liman breaks it down. Calling something retaliation doesn't make it retaliation, just like calling gossip harassment doesn't transform it into an employment violation. It's still gossip, public, messy, and protected by the First Amendment. You don't get to weaponize employment law because your PR took a nosedive. What made the dismissal even more devastating was how Lively's own complaint betrayed her case. The court listed her alleged injuries one by one. She missed a corporate event for her product line, skipped TV appearances, lost hosting gigs, saw declining sales. Every single harm flowed from public perception, not from any employer or workplace action. Judge Liman's logic was airtight. These aren't HR consequences, they're market consequences. When your brand suffers because people don't like you anymore, that's capitalism, not discrimination. The order practically radiates disbelief. This isn't workplace drama. This is influencer drama. The false light and aiding and abetting claims? Liman brushed them aside like crumbs off a table. They were just more reputational injuries dressed up in legal costumes. Lost partnerships, canceled appearances, negative sentiment, those are PR problems, not violations of New York human rights law. Here's where Liman's ruling becomes a warning shot across the bow of every celebrity lawsuit trying to silence critics. He wrote that accepting Lively's theory would open a terrifying door. Anyone, anywhere could be sued in New York for saying something online about someone who lives there. Journalists, commentators, Twitter users, all potential defendants. The floodgates would burst open. Liman slammed that door shut. Speech isn't a crime just because it damages your brand. No court is going to rewrite constitutional protections to salvage a celebrity's image. This wasn't just about dismissing Wallace. It was about reaffirming that free speech still trumps public relations spin, even when the PR belongs to an A-lister. This ruling didn't just land hard, it landed at the worst possible moment for Lively. Summary judgment motions are due soon, and now Wayfarer's legal team can march into court, waving Liman's order like a battle flag. They can argue that every other retaliation claim in the case suffers from the same fatal flaw. They're all defamation claims in disguise. If Liman agrees, and his reasoning suggests he might, the entire lawsuit could implode before the next filing deadline. This isn't just a procedural setback. It's the kind of precedent that devours your case from the inside out. Every remaining defendant will cite this order, line by line, to argue their dismissal. The dominoes are lined up, and this was the first one to fall. For nearly a year, Lively has positioned herself as the victim of a coordinated smear campaign. She's accused Justin Baldoni and Wayfarer of weaponizing media and public opinion to destroy her career. But Judge Liman just flipped that narrative on its head. He essentially ruled, no, this isn't retaliation. This is speech. This is public commentary. This is criticism. The irony is brutal. The thing Lively is suing over, the public discourse about her, is the exact thing protected by the Constitution. What she calls a conspiracy, the law calls free expression. What she frames as workplace punishment, the court sees as people exercising their First Amendment rights. For Wallace, this is total vindication. For Lively, it's a disaster wrapped in a federal court order. Her case just lost its alleged mastermind, its narrative spine, and most of its legal credibility in one clean strike. Every filing from here forward has to overcome this precedent, and federal judges rarely reverse course on jurisdictional dismissals. The dismissal technically allows Lively to refile in another jurisdiction, but the tone of Liman's order makes one thing clear. He doesn't expect this particular theory to survive anywhere. Moving the case would require gutting every New York connection and rebuilding the complaint from scratch under different state laws. And in some jurisdictions, pushing weak defamation claims too aggressively can result in anti-SLAPP sanctions, meaning Lively could end up paying Wallace's legal fees. Even beyond Wallace, this ruling casts a shadow over Lively's entire legal strategy. When a federal judge starts describing your employment discrimination claims as reputational injuries, that's judicial side-eye. It means the court sees the emotional appeal but doesn't buy the legal framework. And once a judge questions your legal theory out loud in a written opinion, every other judge involved in the case afterwards will read it too. By the final page of Liman's order, the message is unmistakable. If your lawsuit is built on the premise that bad PR equals workplace discrimination, you don't have a lawsuit. You have a press release with footnotes, and federal courts don't exist to manage celebrity image crises. This wasn't a ruling against speaking out about workplace issues, it was a ruling against warping civil rights law to serve public relations goals. The story that was supposed to expose systemic injustice now exposes legal overreach. Judge Liman didn't fall for the theatrics. He followed the law. And the law said what it always says. Reputation is not employment, embarrassment is not discrimination, and bad publicity is not persecution. Blake Lively walked into federal court claiming she was the victim of a conspiracy. She walked out with Judge Liman's ruling, making it clear what she's describing isn't illegal retaliation. It's just the internet being the internet, and there's no law against that.